Hey everyone, I just got some great news yesterday and I had to crank out a quick update for my friends, clients, customers, followers, and everyone else impacted by the Corporate Transparency Act. Well, there's huge news right now affecting every small business owner in America. A federal court just handed small businesses a massive win, and I'm breaking it down for you right now. On December 3rd, that's 2 days ago, a Texas federal court hit the pause button on the Corporate Transparency Act. You know, that law requiring all of us to report our business ownership details to the government. This is massive, and here's why it matters to you. The court called this law quasi Orwellian and basically said Congress had overstepped its bounds. This means, in my non lawyer, non legal advice opinion, that first, you do not have to file your beneficial ownership information report by the January 1, 2025 deadline. Second, all 33.3 million American small businesses are protected from this unconstitutional act of Congress. And third, your privacy rights are now being defended. The lawsuit challenged the government's right to collect our private business information, arguing it violated multiple constitutional rights, including the Fourth Amendment's protection against unreasonable search and seizure. And guess what? The court agreed. Now, as I mentioned, I am not an attorney and I am not giving legal advice here. For that, you should consult your own legal counsel. But I have read and watched many comments from numerous lawyers discussing this case during the past 24 hours, so you don't have to. I've also read the entire 79-page order by Judge Mazant granting the preliminary injunction requested by the plaintiffs in this case. After all that, I can report that each and every one of the reviews from lawyers came to the same conclusion, that the law of the land right now, which is Thursday, December 5, 2024, is this. The Corporate Transparency Act and its regulations to be administered and enforced by the Financial Crimes Enforcement Division, also known as FinCEN, cannot be enforced while this preliminary injunction is in place. So, unless and until this order is modified or becomes a permanent injunction or is otherwise acted on by the courts or Congress or both, I will not be filing a beneficial owner information report under the Corporate Transparency Act on behalf of the entities in which I exercise any control. Naturally, you should make your own choice about what to do based on your own evaluation and independent legal advice if you decide to seek legal advice for yourself. I have to agree with the many lawyer comments I read and watched since I learned this news on December 4th, which was yesterday, and after I read that entire 79-page document, that there is currently no requirement to comply with the demands of the CTA. I'll leave a link to the PDF of this decision on the description below so you can download and read it for yourself. I find it really interesting and, in my opinion, refreshing that the court actually stated in its memorandum opinion and order that this law is a quasi-Orwellian statute. They went on to state that despite attempting to reconcile the CTA with the Constitution at every turn, the government is unable to provide the court with any tenable theory that the CTA falls within Congress's power. And even in the face of the deference the court must give Congress, the CTA appears likely unconstitutional. Accordingly, the CTA and its implementing regulations must be enjoined. And it continues and concludes with this. Having determined that the plaintiffs have carried their burden, the court grants plaintiff's motion for a preliminary injunction. Therefore, the CTA 31 U.S.C. paragraph 5336 is hereby enjoined. Enforcement of the reporting rule 31 CFR 1010.380 is also hereby enjoined, and the compliance deadline is stayed under paragraph 705 of the APA. Neither may be enforced, and reporting companies need not comply with the CTA's January 1, 2025 BOI reporting deadline pending further order of the court. And finally, It is therefore ordered that plaintiff's motion for preliminary injunction, docket number 6, is hereby granted. It is so ordered. Now, while this is a huge win, remember it's a preliminary injunction, meaning it could change, and that change could even happen quickly. In fact, I fully expect the government to appeal. They may even seek an emergency order to stay the injunction, which would effectively cancel out this big win while the matter is litigated. But at this stage, I'm optimistic that the preliminary injunction will continue during litigation in this matter until it's finally resolved. So, make sure you're subscribed to this channel for updates as the story develops and this case proceeds. I'll be watching closely each day for any additional updates, and I will post any important news about it here on this channel as soon as it happens. So, hit that thumbs up button if this news makes your day as much as it makes mine. And also subscribe and hit the notification bell so you don't miss any new videos, especially updates on this case. As for me, I've waited until the very end of the year to file my own BOI report under this Orwellian, as the court calls it, statute. And now, unless this order is reversed or amended, I will not be filing a BOI report unless or until required to do so. After all, I, like my audience, am a law-abiding entrepreneur. As of right now, the law of the land is that the government may not enforce the requirements of the Corporate Transparency Act. So as always, I will abide by that law. Right now, as a fellow business owner, I will celebrate this victory right along with you. So drop a comment below and let me know your thoughts on this development. Until next time, have an absolutely awesome day.